Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. My name is Thomas Vick of Vick Law PC in Greenwood, Indiana, and I am joined by Seth Wilson, as always, of Adler Attorneys in Noblesville, Indiana. And we have another program lined up for you today to talk about a couple issues. Seth, what are we talking about today?
Well, Thomas, it's good to see you as always on this rainy March day. I thought it'd be good to kind of chat through your weekly digest blog post on the 4 common estate planning myths that folks often have questions about. And I think we probably both in our practices answer these questions with some degree of regular occurrence, which is why they're fairly common. So thought maybe I'd ask you kind of a couple of them, and then you could flip the table on me if you'd like and ask on the other side. So
Sure.
one of the myths is always that question of, if I have a trust and I'm avoiding probate with a trust and all the other benefits of a trust, I don't need a will, right?
That is a myth. That is not true. Even if you have a trust, you still need a will. A trust is only as good as it is funded. And if you haven't funded the trust fully, you need the will as a backup plan. If there's any asset, say it's, a bank account that didn't get titled into the trust while you were living, then your will, in all likelihood, is going to govern what happens with that bank account. And you want to be able to say, in your will that if I didn't get everything titled into the trust, pour everything over into the trust. That's what we call a pour over will. You pour over into the trust, and then from there it can be distributed along with the other trust assets. So that one is not true. If you have a trust, you do need a will. You do need a will. Let me throw one back at you, Seth. How about the idea that trusts are only for ultra high net worth people? Is that fact or fiction?
Well, it's fiction in the terms of we can all benefit from a trust, right? So I think in the sense of, I think how it was laid out on the 4 common myths was, hey, only high net people should have a trust, and that's not a true statement at all, right? So yeah, we can benefit from it, but again, does it make sense is ultimately the analysis. There are some additional cost factors in putting together a trust because it is a little bit more complicated. And how I typically talk about this is we want to look at what assets you have, anticipate having, maybe anticipate inheriting, and stack those up in terms of how they need to be addressed in your estate plan, and determine if the cost to effectively do probate now while you're living, which is kind of what a trust is, or save that cost for later, makes more sense. And so I think those are factors to consider as part of the trust, is how many assets you have. But there's also plenty of other reasons to have a trust. If you want to maintain privacy about what you own and how that's to be distributed, trust can be a good vehicle for that. You have better control typically in a trust, and oftentimes in a will, you'll have a minor's trust to protect those funds for the benefit of a minor beneficiary. And that's a testamentary trust, but it's still a trust document. So that's helpful as well. I think trusts are also very helpful in the event of an incapacity, where during life you may have a temporary situation where you're not able to manage your own funds or make your own decisions at a time, and a trust allows your trustee, in conjunction with some other things we'll talk about in a minute, to help navigate those temporary periods of incapacity during life as well. And ultimately, trust help avoid a probate situation, which goes back to sort of the privacy idea and working through that. So I think the other benefits of the trust are worth a discussion with an attorney to understand your particular situation. I think there's a lot to be said that if you're not going to use it because you feel a little too intimidated by the complexity or the additional retitling of assets that may be required, potentially a trust is not the right vehicle for you and your family, because as you mentioned, if you don't fund it and take care of it appropriately, you may end up in a probate situation anyway. So great question, though. I would say trusts are for the right scenario, not just ultra high net capacities. So, hey, great question. So I kind of alluded to this as I was talking, but if I do have a trust, certainly I don't need a power of attorney.
That is a myth. That is a myth. There are circumstances that you can't necessarily anticipate that will not be addressed by a trust. And the example in the blog for today is that an IRA cannot be held by a trust. It can't be owned by a trust. And so, if you're the owner of the IRA, your trust isn't going to help you. You need to have a power of attorney to be able to fix that situation, whatever the IRA might be. If an individual becomes incapacitated, you'll have to petition the court for authority to deal with that IRA rather than having a power of attorney, and you would be able to do that in a much easier fashion. So yeah, you need a power of attorney, and in a lot of situations, a trust is the best route to go with estate planning. So there's the answer on that one. The next one I'll throw back at you is my loved one is in the hospital. However, I'm their spouse, daughter, sibling. So of course the hospital will tell me about their medical status and let me make decisions for them. Is that fact or fiction?
That one is unfortunately not true.
Yeah.
And I think we're fairly familiar with that societally now, especially in coming off of the pandemic and those kind of things, where the federal privacy regulations or HIPAA became sort of a buzzword in terms of, hey, can we release this type of information or not? And it called into question sort of the boundaries of what that privacy right is to your healthcare information. And so I would suggest to most of my clients in this sense of the medical side of things that you prepare a release authorization form that accompanies a properly prepared healthcare designation, power of attorney, et cetera. A little bit different terminologies folks might be familiar with, to make sure that whoever you would like to have access to your medical information is already authorized by a release form to do so, because there are many situations that we've come across in our practices over the past several years where unfortunately someone was not listed, and just because you're married to the person or your daughter or son or niece or nephew, that doesn't release that individual's information for public, so to speak, disclosure. And the medical provider and communities are very sensitive to this now, especially in the world in which we live. And so they're trying to be very careful to make sure all their T's are crossed and their I's are dotted. And so make sure those folks are listed on a release form that's properly executed, along with that healthcare power of attorney or healthcare representative designation that authorizes the decision maker and anyone else that you may want to have information to help the decision maker make those decisions at the appropriate time.
Right, right. Good stuff. Good stuff. Everybody needs to have a HIPAA authorization. That's one of those documents that even if you're just 18 years old, you should have one. That's one of those, going away to college kind of presents that you give to your kid. Make sure that there's some HIPAA authorization, some kind of advanced directive where parents can take care of the college student if something happens to the college student. So good points on that.
Yeah. Can I add one thing? We didn't really talk about this. I know you and I have discussed this in the past, but I have a graduating high schooler this year. And as part of the college visit discussions that we've had with admissions folks and financial aid folks, one of the things, because my son is 18, they've had him sign a release to allow me as a parent to have access to his information. That is one of those things to really consider, because you won't have access to their medical, you won't have access to their financial aid, you can't access the grades, all of those things, once your child turns 18, changes that dynamic for them. And so it could be a good thing to have that power of attorney in place And you can set them to expire after a number of years or different things. If the child is like, well, I don't want you to have access to everything forever. Agreed.
Yeah.
It needs to be a balance. But that can be very helpful, especially if there's medical care or questions that come up while the child is away at school or training or whatever that may be. So definitely something to think about as they phase into that next stage of life.
Good stuff. Good stuff. Well, real quickly here, the final blog post that went out today was five unexpected probate costs. So let's kind of hit these fairly quickly. The first one is court costs, and here in Indiana, it doesn't cost a ton to open up an estate administration or whatever it might be. Some filings don't even have a fee when it comes to estate, filing something in the probate court. But court costs, that can be, $177, $182, something like that here in Indiana. So not a crazy amount. And then executor costs. Kind of talk about executor costs in a probate administration. So
Yeah, it's interesting. So we see different terms for this, but this could be the personal representative, the administrator of the estate, the executor of the estate, just different terms for the same position. But this is the individual or individuals who are responsible to navigate the probate process, gather assets and liabilities, and make sure everything's accounted for. And so that takes time and it takes effort on the part of the personal representative, executor. So there could be a fee to the estate to compensate the executor for that time. And that's a reasonable fee typically determined by the court, depending on the size of the estate and basically how much work was required. And that has a corollary, which is the attorney fee side, because typically the personal representative or executor is represented by the attorney to navigate that process. And so there's two potential costs there.
Yep. Yeah, attorney fees are definitely part of that. Attorney fees, in Johnson County, they've got some local rules about how much the attorney fee in the state should be. There are always exceptions, but how much it should be, and then how much a personal representative's fee should be. So some of it is dictated by local rule. And then there's accounting fees, and this is something that the attorney can help out, or it might be a CPA that helps out with the accounting for the estate. But if there are a lot of securities, stocks and bonds, and things that have to be exchanged or sold off, that can add quite a bit of complexity and can be a significant cost in how much the fees are going to be in a probate administration. And so, yeah, those are basically the fees, state administration fees, executor fees, all of those things go into maybe why you want to avoid probate.
Yeah, and I would add on that last for the estate administration fees, though those are what I would consider sort of the costs of analyzing what's in the estate. So if you need an appraisal done or a personal property evaluation done, or you need to hire a realtor to sell a house and make sure that that commission is paid, those are all things that will come out of the estate proceeds or be part of the process of wrapping up. Now, with a trust, you're still going to have some of those fees incurred by the trust, by the trustee. So it's not that you avoid fees and costs of administration, so to speak, with a trust, but there are other things, and especially the time aspect and the attorney fee side on the trust, where that's why I often talk about a trust in terms of kind of doing probate now, and that's why that cost is a little bit more expensive at the front end. However, you're doing most of that retitling work and setting things up the way you want it to go. And so instead of paying a trustee or paying the attorney to advise the trustee at the time, which you might do through a probate process to get that finalized. So just kind of a balance there. And it needs to be, I think, a whole picture analysis so you can be well informed and make the right decision for you and your family.
Right, right. Well, good stuff today, Seth. As always, I appreciate it. Let everybody know where they can find you.
You too, Thomas. I am up in the heart of Hamilton County, right here in Noblesville, Indiana, and you can find us at noblesvilleattorney.com. How about yourself?
My name is Thomas Vick. I'm the attorney at Vick Law PC. I'm located in Greenwood, Indiana, and you can find me by going to vicklaw.org. Always appreciate it, Seth. We'll talk to you next time.
Sounds good. See you.